I think on the work side, reduced bureaucracy. As I think was mentioned in the seminar, there's now no longer going to be any control on the employment of local people, whereas up to now you've had to have a quota for local people as well as non-local, so that's done away with. Also a level playing field in terms of change of control, and also in relation to JCATs, as we call them now, which could be licence posts under the new law. Now the quota will be by reference to the particular type of work and not specific to individuals. So again, a lot less bureaucracy there, flexibility for employers.
We'll go into some of the elements in a bit more detail in a moment, but I mean, how important do you think this new legislation is?
I think it's important in terms of having a more systematic approach to the two ways in which migration to the island is controlled, and the occupation. So the occupation of property on one hand, and business licensing and employment of staff on the other hand. The two laws have been sort of operated together administratively, but this knits them together properly, introduces consistent terminology, allows it to be policed properly, and, as I say, it reduces bureaucracy in quite a few instances.
Now, you just briefly mentioned J categories a moment ago. At the moment, J categories are applied for a person for the company, but when they move on, the J category goes. But that won't be the case in the future, will it?
No, that's exactly right. I mean, at the moment, a business, I mean, if I think of our business, we have a number of J category people occupying various roles in administration and in law. But they all have to be applied for individually. So if you apply for John Smith, trust lawyer, he then moves on in due course. You have to make another application. Now you'll have a quota by reference to specific work descriptions, and you'll be able to allocate those as you choose as an employer to your employees. Person moves on, you get somebody else in. As long as they're fulfilling that description of work, then there's no need for a further application.
And is that much better for business going forward?
Well, I think so. It's less bureaucratic. It's more flexible. And I think it's consistent, as I say, with this general approach of reducing bureaucracy where appropriate.
Now, there has been a lot of grey areas around sort of change of ownership, but the new legislation will help improve that, won't it?
It certainly puts things on a level playing field, and because at the moment, pre-1973, businesses which were either started before the law came into force in 1973 or indeed had regulation of undertakings licences granted up to about 2000 didn't have changes of control conditions, whereas since then, in fact, the pendulum swung the other way. New businesses starting since about 2000 have change of control conditions, so even selling 5% of the shareholding of the business, for example, you have to make an application to the Population Office. Now, all businesses will be on the same level playing field, and it's only what's known as a significant change of ownership, which essentially means going below the threshold of 60% local ownership, which requires an approval from the minister. So it's a level playing field, and it's actually a relatively light touch in terms of the what's controlled.
Now, you said the new legislation tightens up the bureaucracy. It also gets rid of some of the red tape, certainly around permissions for employing local people, doesn't it?
No, that's right. I mean, I mentioned the quota system for licence posts, but certainly the new designations of entitled and entitled for work. So essentially what we refer to as currently as locally qualified for work purposes, so 5 years residency plus. There's no restriction on employing persons within those categories, and so whereas at the moment you have your specific staffing licence, specific quota for local and non-local. Whereas, so I think that's a great improvement, and it's consistent with the sort of policy objective of supporting those who have an existing connection to the island through long residency or otherwise. That they are the people who the state is seeking to protect in terms of employment opportunities. And it's consistent with that, I think.
And when will all these changes start to be introduced?
Well, the indication is that 29th of April will be the implementation date. I think in the next few days there'll be an appointed day act going before the states, lodged with the states for debate shortly. So we've got about 6 weeks until it comes in. and the various supporting ministerial orders are going to be published very shortly. So we'll see some of the fine detail among fees, for example. People will be interested in that. The fine detail of exemptions and such like. So there's a run-up period now, but it's obviously close. We need to pay close attention to it now, but there's still a little bit of time for consultation and acclimatisation.
As you said, it's close, around about 6 weeks' time. If anybody does need further clarification, what should they do?
Well, I think that there's probably two strands to that. I mean, first of all, liaising with the Population Office in relation to such things as how the existing J category permissions are going to sort of migrate into new licensed allocations. And I think the Population Office is going to be closely working with business in any case. But, I mean, there are going to be specific questions that businesses have relating to their own circumstances on the employment side. And so, yes, professional advice will be necessary. We're very happy to give whatever help we can to businesses.